Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We got a question here, and it's a bit of a whoopsie, because it looks like it was from 7 months ago. I've been going through some older questions because YouTube doesn't email me the comments anymore, so I've been going through a backlog of some of the older comments answering questions, and it looks like we missed this one. So from 7 months ago, we've got a question from Don't Worry About a Thing. YouTube user, Don't Worry About a Thing. And Don't Worry About a Thing says, Vince, can you answer the question of why a defendant's representative, not an actual attorney, will not present my offer to their client? Can they even do that? Pause. Let's answer that question. So attorneys do have an ethical duty to carry a settlement offer to their client unless... and I understand this person's not an attorney, but we're going to answer the question in total. The attorney has an ethical duty to carry a settlement offer to their client unless their client has previously indicated such a settlement offer would not be acceptable. So one thing my client can say is, hey, I don't want to hear about any settlement offers under $1 million. Say no more, fam. You got it. Now, that might be a bad idea, and I might tell the client, hey, listen, that's not the best idea in the world because your case is worth like $300K. So you saying you don't want to hear any settlement offers under $1 million, yeah, probably not going to get this settled. And that's okay. That's your prerogative. We can always try the case, but I'm just saying it could be a bad idea. Counterpoint, could be a case worth $5 million, right? So I'm like, hey, yeah, why would we talk about settlement offers under $1 million? Thank you for the authority. It saves my time. I can tell your employer, yeah, I'm not even going to take offers under $1 million to my client. My client's been clear. She or he does not want those offers. So that relieves me of the ethical duty to carry all offers to my client. So if this person, this representative, was an attorney, that could have been what was going on. Now, there's an additional thing going on here that could still be what's going on. They could have pre-existing authority or pre-existing directives from their client. But also, and I don't know what jurisdiction you're in, but you're in an administrative agency with an administrative judge. And I don't know where you are. It's possible that this non-attorney doesn't have that ethical duty. So that is also a possibility. It's also, listen, let's be frank, it's possible that this non-attorney just doesn't have a license and is not as aware of her or his ethical duties and is breaking an ethical duty. That is entirely possible as well. That happens in the world. And it happens more when you have non-attorneys, because non-attorneys working in the realm of employment law don't have licenses to lose. And so they don't care about things that attorneys might care about, because the attorney's like, whoa, I really value my license. It's how I earn my livelihood, right? And this non-attorney's like, yeah, I don't have one of those. I don't care. And so they don't learn about their ethical duties, and sometimes they play fast and loose with the ethical guidelines, and that happens as well. So that's one possibility. But you have a lot more questions, so we answered that part of the question. Let's go on. I had one call with her, to which she evaluated my case to be worth less than $30,000 before summary judgment. I said I will not settle for less than 6 figures during some back and forth in emails. I am pro se, meaning you're representing yourself, but I have done my research. You'll have to take my word. I've spoken to some lawyers that wanted my case, but through the 1-hour consultations, none would evaluate my case. That's interesting. It's odd they wouldn't evaluate your case. If you're saying they didn't want to do a damages calculation, yeah, obviously. They're not going to take 5 hours to do a damages calculation on a case they're not working on. But I hear you. I mean, they should have a conversation with you back and forth about your case. One thing which caught my attention was she said she evaluated my case to less than 30 before the administrative judge had even made a decision about the claims. Do you think after summary judgment their evaluation will go up? If you're willing to hear a little more, I'd be happy to pay you any fee for an hour or 2 of your time. Okay, so listen, this was 7 months ago. I don't think you want to buy my time anymore, and I wouldn't feel great about it if you did, because we charge the hourly rate for our attorneys here, for partners here, is $1,160 per hour. So I wouldn't feel great about charging you thousands to get me to chat about your case. Like, that wouldn't feel good. But at least we're doing this video for you. That's better than nothing, maybe. Although, I mean, at this point, your case could be resolved, or it might still be going, for all I know. Couple of things. So you mentioned administrative judge. This tells me you're not in state court and you're not in federal court. You're in probably a state agency somewhere, is my best guess. Now, I don't know what jurisdiction you're in, but something you could do And many of the state agencies, you can look up their average verdict and their average settlement amount. This is something you can do in the New York State Division of Human Rights, for instance. And listen, while my firm has produced some really great results in the New York State Division of Human Rights, I'll be upfront with you. I think the average result from an administrative law judge in the New York State Division of Human Rights is something like $32,000 off the top of my head. I think it's something like that. And it changes year to year, but generally it's under 40K. So that could be something that's going on where you've got a great case, but you're in an agency that's got lower amounts in terms of verdicts. This could lead to the valuation you're facing from this representative, right? Excuse me. Now, in addition to that, you're pro se. So you could have a six-figure case, the best case, all the best facts, all the best evidence, and they could just doubt your ability to try that case. Because let's be honest, and this is no shade on you. I don't know anything about you. I'm sure you strike me as a savvy person, a savvy and competent human being, a scholar and a gentleman or a lady of distinction, or anything else, any other way you'd like to identify yourself. Now, that doesn't change the assumptions about a pro se litigant. No matter how amazing you are, the reality is that 99% of pro se litigants can't try their case for shit. They are self-harm machines who just waste everyone's time and then shit on their case and get $0. That is what a pro se litigant is 99.9% of the time. Pro se litigants representing themselves are just human beings engaging in self-harm. That's really all they are. And listen, I know successful pro se litigants. That's why I make room for that tiny sliver, that tiny statistical sliver of successful people. There's people on YouTube who represented themselves and have YouTube channels now where they try to help other people to represent themselves. And that endeavor is incredibly noble. And it's amazing that they represented themselves. But I don't know how many people they actually help, because most pro se litigants are incapable of trying their case. Now, they're not incapable of getting a settlement. Certainly, pro se litigants can settle their case. That is, mediation is a much simpler thing than trial. People sitting around talking about giving you money is a much easier day than trying to figure out how to present 1,000 different forms of evidence under an esoteric set of procedural rules during a fast-paced trial where nobody's going to help you. Those are two very different things, right? So let me be clear. Got a fly in here. Not saying pro se litigants can't settle a case, but I'm saying statistically they can't try a case. Oh, this fly bugging me all of a sudden. So that is the reality of how I perceive pro se litigants and how almost every attorney in this industry perceives pro se litigants. There's a lot of defense attorneys who will make, and I've seen this happen. I've seen pro se litigants get offers of, $2,500, $5,000, $10,000, $15,000, and then they get an attorney, and all of a sudden the offer is, whoa, it's $250K. They hired a good attorney. The case actually has legs now. It's not just someone being like, I want money, which is what a lot of pro se litigants do. Something just beep. A lot of pro se litigants are just like, I have a good case, money. And that's, they don't know how to use evidence as leverage. Like, well, do you really want to face a retaliation claim here? Because listen, my protected activity took place on such and such date, and then right after that, I suffered a negative workplace consequence. So the burden shifting, and the burden shifting is not going to favor you. So that's a pretty scary claim for you, defense counsel. You want to lose big on that one, and they don't know how to do that. Why would they? It's not their job. They've never done it before. Makes sense they wouldn't know how to do it. I don't know how to do what they do, right? Let me be clear. I'm not mocking pro se litigants. I mean, I guess I am. But not in a mean way. What I'm saying is hey, this isn't what they do. So it's unsurprising that they don't know how to do it. And so very few people are successful at it, right? I guess that's my point. So you may have an amazing case. You may certainly be right about the six-figure nature of your case. But you're pro se. So nobody thinks you can do anything about it. So they're not going to offer you real money. And further, you're at a state agency, looks like, I assume, and the average verdict in that state agency could be really low. So you could have two separate things that cause your amazing, very valuable case to be reduced in value because you just don't really know any better. Not your fault. It's not what you do. But I'm letting you know those are two things that jump out at me from your one paragraph of information that you provided me that drastically, if I was defending this case, those two factors, $500,000 case, I'd be looking to get it done for 20 grand. Pro se litigant in a state agency, oh my God, this person's just killing their case. That's what I would think if I was defending that case. And so I suspect that could be what's happening because you tell me, and I'm forced to take your word for it, that you have a great case. You've got a 6-figure case. I believe you. But a 6-figure case in a state agency being litigated by a pro se litigant, 30 grand seems generous at that point because you got a lot of things stacked against you. You made some decisions that I can see why you made them, but they're going to reduce the perceived value of that claim in the eyes of defense counsel or defense representation. That can be really frustrating. And listen, you might come back and be like, joke's on you, Vince, I settled my case for $500,000. Amazing. I'm super glad that you beat the odds. You beat the statistics. I'm not saying you can't beat the statistics. I'm saying, hey, if you're asking me why this person is saying your case is only worth $30K, these are two really good reasons why she might be saying that. That's all I'm saying. I'm not saying you're not competent. I'm saying statistically, it's unlikely you're competent enough to try this case. You seem amazing. She just wouldn't know that. She wouldn't know that you're amazing, so she might make a mistaken assumption that you can't try the case, right? Anyways, I digress. I hope this is helpful. If it was, like, subscribe, comment down below. Quick note to everybody. We have had a rash of settlements recently, which is great. I love settling cases. If it's the right number, if it's the right number, if the client's happy, that's good. But it leaves us in October about 20 open slots for new cases. And so we are looking for cases right now. If you're always check with your local counsel first. Local counsel will be cheaper. Shop around. But if you have some kind of reason why you want, national representation, give us a call. Just remember, listen, we're an expensive option. I'm not going to play games here. Like, we're an expensive option, right? And people are going to call me up and be like, how could you be so expensive? People hire me all the time. I'm not worried about that. Listen, you can be as mad as you want about that. My price is my price. We're worth it. But my point is, if there's a reason why you need more expensive representation, if there's a reason why you need a national firm that's going to fly attorneys in for you, if there's a reason why you don't want to use local counsel, or if your local counsel options are meager and just unacceptable, at that point, I would say give us a call. We're looking for cases. Love to have a conversation, see if we can help. Anyways, I'm done shilling. Take care, everybody. I hope this was helpful. Bye-bye.